Hoyt.
Good morning. How you doing?
Good. Looks like you're the only one here to argue today.
Yes.
So you have 15 minutes and you may proceed when you're ready.
Okay. Thank you. Thank you much. Start with a little background on Winley Motorsports and what it's all about. Mr. Winley buys cars at auction primarily. ADESA. At this time, he was buying it at ADESA and I think OKI. And primarily, these are dealer trade-ins where dealers don't, they're high mileage cars, usually over 100,000 miles. His intent is he sells these cars in a place from $3,000 to $6,000. So usually there's something wrong with the cars. Usually it's minor. He has, he cleans them up, fixes them up, and puts them out there and sells them as is for $3,000 to $6,000. Usually, his profit margin is really small on these cars. Usually about $500,000. He sells about 100 of these a month in the first 6 months of the year, and and he sells them as is because he buys them wholesale, sells them wholesale. I've seen the NADO book on a lot of the vehicles, and they are wholesale prices. So he does about 100 of these a month. And this car was sold as is. The buyers, signed and all the exhibits show the as is. He did everything by the book as far as notifying them and everything else. And they admit that. They admit to their signatures. They had the opportunity to test drive the car. They didn't make any accusations in the transcript, if you note, that they were promised anything or told anything. But they had the chance to drive it. They had this car for a month. They drove this car for a month before they had experienced any problems. And apparently they did experience some transmission problems, shifting problems. And they took it back to Mr. Winley.
Can you help me out? How did the girlfriend or the fiance come to start working there?
She lost her job apparently for some reason, and they were having trouble paying for it. And they were a good customer, I think, and he'd sold them several cars in the past. So he let her come to work there to help pay for the car because they still owed on the car. They had paid, I think, $3,600 down and were making payments on the car, made a couple payments. So that's how she came to work there. Well, Mr. Winley changed a couple of the solenoids. He still thinks that that's the only problem was his solenoid, which, the computer runs things in cars anymore, and it uses these solenoids to change things in the transmission to transfer messages. And so he replaced a couple of those. Well, apparently, this is her claim that 3 months later, don't have the exact dates, but it was a long time later, she got into his computer and she claims, and she showed these photographs, Exhibit 1 and Exhibit 2, I think they are, of the vehicle. She claims that we're out of Mike's computer. He disputes that. He says,
but the magistrate agreed with her, right?
Apparently so. She said that I think she found fraud in the case.
Mr. Hoyt, she actually testified, correct?
Yeah. Yes, she did.
So she was there.
Yes.
Okay.
Yes. She testified that she took those pictures off of his computer. He denied that those pictures were off of his computer. He said that anything on his computer has his name on it, number one. But the big thing is, I mean, why I said about how much his transactions and how much he does, we're talking about 3 months after they took the vehicle and drove it for a month. 3 months later, they find this in the computer after the car had been worked on. And I think that even if these were in his computer, there's no proof to when they were put in. They were working on the transmission. He has several people working in there. Even if they were in his computer, which he denies, he didn't recognize these photos as coming from his computer.
Well, but
even
I
if they
guess
were.
part of my concern with the way you frame this appeal is you say in the first issue for review that, you know, there's a genuine dispute of fact, but I mean, the magistrate resolved that issue of fact against you, and then the court agreed with that. So, I mean, don't we have to defer, even though there is disputed evidence, don't we have to defer to what the magistrate and the court ultimately found?
Well, I don't know. Fraud takes, there's 6 elements to fraud, and the first one is even concealment. Was there a concealment? A car sold as is. As is no concealment. It's as is.
But Mr. Hoyt,
So right
if-
there
if-
off the first thing for fraud,
Mr.
even
Hoyt,
if she, I'm sorry.
if he purposely hid that, which the magistrate appeared to find, he was still allowed to make a fraud claim, correct?
If he purposely hid that, but as is as is. There's no purpose. I mean, if I tell you as is, that's as is. And there's no evidence to show that he even knew that was buried in his computer. There's no evidence of that. Even if she believes that yes, this person did get it out of his computer, that's all she can believe, right? That's all she can believe, that it come out of his computer. Now then, what about the other elements? Where's the concealment? As is as is. Where, is it material? I don't know. $150 part, might still claim at the end that it still needed just another $150 part. And yet they didn't date that. Now, made falsely with knowledge of reckless disregard, made falsely. Where's the made falsely? As is as is. That's not false. And when you buy these at auction, they don't disclose this stuff. They sell them as is. There's no checkout disclosures on these cars. Sometimes they sell them with warranties. Now, then, then there's disclosures, but as is as is. And intent to mislead, I think you have to show that Mike knew that was in there. And when he sells something as is, that's like saying, I don't, there's no warranties, no nothing, no disclosures, no nothing. So I don't know. Damages, even as far as damages go, I think there's an issue with damages because, like I said, he still believes there's another $150 part is all the problem that would resolve their issue, which I think you should take notice that, he was making efforts to try to fix this car for these people. And as far as I know, not charging them other than for the parts that he was trying to do. And that was three months after the purchase. So that's my case in chief. Sorry, but it all relies back, I think, on what is as is.
No, we appreciate your argument, understand the points, and the case will be submitted and we'll get out a timely written decision.
Thank you, sir. Appreciate it.
All right, thank you for your time.
Have a nice day. Stay safe.
You too. All right, good morning, everybody. Welcome to the First District Court of Appeals. Ms. Vance and Mr. Pascal, are you intending to divide argument, or is one of you going to take the whole time?
I believe Ms. Vance has allowed me to go ahead and use the full 15 minutes, Your Honor.
That's
Okay.
correct.
Great, thank you.
Yep.
And Mr. Butler, how much time would you like to reserve for rebuttal?
4 minutes, Your Honor. Thank you.
4 minutes. Okay, you may proceed when you're ready.
All right. May it please the court, my name is Brian Butler and I represent Dr. Vladimir Bogdanov in connection with injuries he suffered in a collision on August 15th, 2015. Now, because the brief went through the facts and the procedural history, if it's all right with the panel, I'd like to skip straight to the argument.
Sure.
But I do want to emphasize that this was a collision that caused pretty substantial damage to both vehicles. Dr. Bogdanov's vehicle was ultimately towed. We're not talking about a cracked bumper or a cracked headlight.
But it was like a 5 or 10 mile an hour speed, right?
Both parties were going between 10 and 15 miles an hour, I believe was the testimony. Although the defendant actually initially gave a statement to the insurance company stating that my client was going closer to 30 miles an hour. So again, but it was not a huge accident. We're not talking about fires and jaws of life, but it was not, like I said, cracked plastic. Now, the standard of review governing the admission of evidence at trial is abuse of discretion. A trial court abuses its discretion when it makes a decision that is unreasonable, unconscionable, or arbitrary, and it includes a situation in which a trial court does not engage in the sound reasoning process. The admission of both hearsay testimony from the defendant's expert and the allowance of repeated leading questions both constituted an abuse of discretion in this case. Now, the hearsay that is at the center of this appeal was not directed at an ancillary issue. It was the ultimate issue in this case. The court allowed hearsay from the appellee's expert alleging that it would be impossible for any motorist, not just Dr. Bogdanov, to be injured in a T-bone collision under a certain speed. Appellee's counsel asked the doctor, in an accident such as this, is there a mechanism for injury for a significant low back injury such as a traumatic tear or herniation of the lumbar disc? The witness responded, absolutely not, and then went on to repeatedly reference scientific studies. And he concluded the scientific studies would show that 100%, there's no way that this type of accident will cause a disc herniation.
Counsel, did the expert testify to any precise statements from the literature, or was it more general?
I would say this is very precise. I mean, it's not, well, we don't know if it's a direct quote or not because we never saw the studies. They were never identified. But that's a very precise statement. It is 100% impossible to suffer a collision in an under 20 miles an hour injury to the lumbar spine. That's a very precise statement involving many facets of science, medicine, physics, everything.
I understand that his statement was very precise, but do you know if I know that you didn't see it, but was he saying that's what the literature said?
Yes, his exact words were, so the scientific studies would show that 100%, there is no way that this type of accident would cause a disc herniation.
Well, but it sounds to me that when he says that, he's basically summarizing kind of the general body of knowledge, which, an expert would be basing his opinion on both like what the literature says, their own experience, all of that. So I guess I see that as qualitatively different than saying like, in this book on chapter 14, it holds this principle.
Well, I think that there are certainly degrees at which these statements can occur. And if you look at the other cases, what was happening is a witness might testify, the standard of care is this based on my experience, and also it's supported by the literature. Now, that's a different case than what we have here. He never went back to say, based on my treatment of of accident victims that accidents under a certain speed, or T-bone accidents versus rear end accidents or head-on accidents, cannot cause this injury. And again, he didn't say it was likely or unlikely or that these kinds of accidents tend to cause or tend not to cause. He said that the studies establish with 100% certainty that this is impossible. And that is a very direct type of statement. And I think it's important also to consider how appellee's counsel used that throughout the trial, because what he said in closing argument really emphasizes the problem with the admission of this testimony. In closing argument, Mr. Pasfall said, this is starting on page 322 of the transcript, and low speed has a meaning in this case because there are studies, medical studies, scientific studies concerning speed at impact in relationship to injuries in automobile accidents. So what kind of injuries can we expect according to the medical scientific studies from a low speed accident such as this? Well, Dr. Wonder told you what you would expect is a neck strain if the impact was enough to cause an injury. But then he continued on page 330 to 331. He told you he's relying on studies, and he described those studies, and he told you what these studies show. And you know this is part of his training and experience. You didn't hear Dr. Egabegi say one time anything about a study he was relying on, or that there was any kind of study or scientific evidence supporting his opinions in this case, not one. And then he continued on 332. The point is the scientific studies show that it is impossible to herniate a disc in this matter, in this case, and in the presentation of this case. And that's why Dr. Wonder's opinion is so credible. It's because he didn't just guess or speculate. So he's telling the jury.
Mr. Butler,
yes.
Mr. Butler, let me ask you, I'm assuming your expert's opinion was that the mechanism of this accident would have caused the injuries to your client. Is that correct, sir?
He did, and that's on throughout his deposition, but you could specifically look at pages 10 and 14, where he testified about how side impacts cause the twisting of the spine, and that, in his opinion, this collision caused Dr. Bogdanov's injuries.
All right, so it sounds like the jury may have found Dr. Wonder, at least his expert testimony, to be more credible. Is that fair to say?
That's fair to say.
Okay, all right, I'm sorry, go ahead.
And yes, Judge, to your point, I think that's the only real issue in this case, because the jury didn't decide that Dr. Bogdanov's injuries were not that severe. They decided he was not injured at all. And when Mr. Patzfall tells the jury that based on studies, Dr. Wonder's testimony is more credible than Dr. Egabegi's, Dr. Wonder has studies, Dr. Egabegi doesn't. It's simply...
Well, but I mean, like, he made an offhand comment about studies. It wasn't like he paraded them before the jury. I guess that's defense counsel taking something and trying to inflate it with importance, but I don't see the substance in the expert's testimony. And certainly your guy could have come back and said, that's ridiculous. Here's why this was caused by the accident.
Well, he did, but I think the issue is Dr. Egabegi, he stuck to the rules of evidence. The evidence was presented in accordance with the Ohio rules of evidence. He did not, simply throw out references to studies that may or may not exist. And so then the witness for the defendant does. And I think it's also important to point out, I sent a subpoena to Dr. Wonder asking for all documents he relied on informing his opinion, so I could be prepared to examine him on these things. And we never got any studies. Those were not provided in discovery. So, Mr.
Did you ask him that question?
I didn't.
I mean, look, if the guy injects an issue of studies and you've asked those questions in the subpoena, I mean, isn't the natural follow-up, well, you didn't give me any studies in response to the subpoena. What are you talking about?
Your Honor, I was stuck between a rock and a hard place to a degree, because I had no opportunity to prepare. I could not cross-examine him on anything like that. I mean, if he just starts talking about what the studies were or presents them to me, I have no opportunity to cross-examine on them because I haven't had a chance to look at them. or look at other literature that might relate to it.
Well, right. But what I'm saying is, like, if he didn't disclose studies in his subpoena response, you could ask him, what are those studies in the deposition? And then if he starts spouting off a bunch of studies, you go to the judge and say, exclude all this.
Well, respectfully, I mean, I that's what I did ask the judge to exclude the reference to the studies, because I mean, he shouldn't have been referencing them in the first place. Look, the rule of evidence is clear. A physician cannot, or any expert cannot, rely on treatises unless they are identified and the court finds they are credible. The Rules Committee, when the Supreme Court proposed this rule in 2006, went through all of the reasons for this rule, and it expressly talked about, this is in the comments, the staff notes to the rule, evidence rule 803.18 contains a number of safeguards against unreliability and misuse. And it continues, the rule applies only to a learned treatise found by a judge to be a reliable authority under evidence rule 104. If a doctor can paraphrase and can just not identify any studies so that the opposing party has no opportunity to assess them, the court has no opportunity to assess them, the jury has no opportunity to assess them, the rule means nothing. I mean, in general hearsay, if a witness gets up and testifies, Joe told me X, Y, and Z, there's an objection based on hearsay. It's not cured by the witness saying, well, Joe told me approximately X, Y, and Z, because it's still hearsay. The point is, the jury needs to be able to assess the credibility of the speaker. The opposing party needs to be able to cross-examine the speaker, and we were entirely deprived of that opportunity when the court allowed this testimony in. Now, in the leading questions, if I could briefly get to that.
But you're at your time if you want to reserve 4 minutes for rebuttal.
Okay, thank you.
Thank you.
Mr. Your Honor, thank you, Your Honor. If it pleases the court, I represent the defendant in this case, Sophie Ann Ayers, who, by the way, is a male, and this was indeed, if I can just address the facts quickly, a very minor automobile accident. The car was not towed; it was actually driven down the road, and then he decided to leave it there. Both cars were going between 5 and 10 miles per hour. Nobody complained of any injury at the scene. There were no symptoms. The plaintiff had admitted for at least 24 hours after this accident. He didn't seek any treatment whatsoever for 5 days after this accident. The plaintiff had a long history of back pain up and down his spine before this accident. He told that to his pain management doctor within weeks after this accident. The same pain management doctor he had been seeing for years. He had been taking tramadol, an opioid, synthetic opioid for back pain for years before the accident. The x-rays and MRI and other studies showed that he had pre-existing degenerative disc disease, spondylolisthesis, and scoliosis in his low back before this accident. And every doctor admitted that those could cause back pain, serious back pain, and other symptoms. This was just a bad case. It shouldn't even have been tried to a jury. But as you know, the jury is entitled to believe or disbelieve any of the witnesses in this case. And clearly, Dr. Wonder was far more credible as an expert witness.
Well, but Mr. Butler says that part of the reason he came off as more credible is because he wrapped himself in the cloak of, these undefined studies, and then you were able to leverage that in closing. So, I mean, he's got a point on that when someone says, I'm relying on something, but I'm not really telling you what that is, that does make them as an expert seem more believable.
Yes, and that's why there's cross-examination, Your Honor. And he didn't ask one question of Dr. Wonder in that regard. And Dr. Agabeki was the most uncredible expert witness I think I've ever seen in my 40 years of trying cases in Hamilton County. He didn't review any of the plaintiff's records from before the accident. He was embarrassed. He didn't review the emergency or the doctor records before he went and saw Dr. Agabeki. Dr. Agabeki didn't review any of the deposition transcripts in this case. He knew literally nothing. Now, the as I've stated, this argument that reference to unspecified studies. Well, first of all, there are literally, and I've read a lot of them, hundreds of studies in this area. He did not specifically cite any treatise, any specific study, or anything. This was part of his training and experience as a very experienced physician. And the trial judge, Judge Guckenbacher, he specifically pulls out the Beard case and goes over this analysis. And specifically, the questions you asked were the questions Judge Guckenbacher asked in chambers when we're discussing this matter. And he made the correct ruling. This is not hearsay. But even if it was hearsay, it was clearly waived because he had never objected to it. And as you know, there's no trial by ambush anymore. That's been gone for 30 or 40 years, except for a few attorneys I know. But anyway, so that's the situation with regard to these, quote, unspecified studies. And the fact is, there's absolutely no studies that counsel for plaintiff brought up or that his doctor brought up that countered this. And by the way, his doctor also referenced unspecified studies. Of course, I didn't object because it's not hearsay. But if I failed to object,
you're saying his expert reference studies, where was that?
it was somewhere in his, I can't do it, and I don't even know if it was about low speed impacts and back injuries, but I know he referenced offhand, just like Dr. Wonder did, their studies in this field, and he referenced them. He didn't specifically state what studies were. He didn't identify them, and more importantly, he didn't pick out any specific statements or findings in a particular study, quote, which might implicate the hearsay rule. So,
well, I guess I think that's the real crux of the question. It's like, it's how direct does your reference have to be to implicate the hearsay rule? And it's one thing if you're just saying, well, based on my analysis of the studies, my experience, et cetera, like obviously that's not going to trigger the hearsay objection. But I think what they're arguing is this crosses the line once you make a specific reference that a study holds X or Y.
Well, Judge, you could throw out all the expert testimony in this case, and the jury would have plenty of evidence to find what they found. So obviously harmless error. But let me read to, but what counsel for plaintiff hasn't told you is that his references to studies came about before I ever asked him any opinion questions in this case. And then on page 53 of Dr. Wonder's deposition, I said, doctor, based on your education, training, and experience and your independent medical examination, do you have an opinion to a reasonable degree of medical certainty as to whether the plaintiff sustained a traumatic herniated disc in this accident or an aggravation of a herniated disc in this accident? Answer, I do have an opinion. And what is that opinion, doctor? I don't believe that occurred. Question, okay, and can you explain the reasons for that? Sure, so no leading question, and I'm not referencing any of those studies. He goes through a specific analysis, which he calls the Bradford Hill analysis of causation and claims such as this. Dr. Agabaghi didn't mention any of that. He didn't go through any causal connection thing. So he said, this is back to Dr. Wonder again. We would go through what we call temporal relationship. Was there an immediate onset of pain or not? And the answer in this case is no. The onset was later. Then you also would then have to look at the science of this type of accident that's been extensively studied. Is such an accident capable of causing a disc herniation? And the answer to that is 100% no. Then we look at the clinical evidence and the imaging studies, and try and see if there's any edema or anything that looks like there is some acute herniation. And the answer in this case is no. And so because of those reasons, I would not relate the disc to this accident at all. So that's the totality of the testimony. And he bases his opinion on his expertise, his training, his experience, and his knowledge of literature in the field. He makes no specific reference to any study. And if counsel wanted to know about him, he could have asked.
All right. Any other questions for Mr. Patzfall? Okay. Thank you, sir. Mr. Butler.
You're muted, sir.
Mr. Butler, you muted.
I think what Mr. Patzfall just said is really the heart of the case. Dr. Wonder talked about how injuries, can occur whether they manifest immediately or later. And Dr. Egabegi did the same. He testified that it's in his clinical experience, it's actually more common for people to have an onset of injury approximately 24 hours, or an onset of pain approximately 24 hours later. And that's up for the jury to decide. But what happened in this case is Dr. Wonder kept falling back to these studies that establish with 100% certainty that it is impossible to suffer an injury. The page that Mr. Patzfall just referenced, page 54, he expressly says again for the second time, it is 100% impossible for an accident like this to cause the injury. And when Mr. Patzfall says in closing argument, ladies and gentlemen of the jury, you have to believe Dr. Wonder more because he has studies and Dr. Egabegi doesn't, that's prejudicial. And it highlights the prejudice of Judge Guckenberger's decision to allow the evidence in. And Dr. Egabegi didn't have an opportunity to go back and reference studies. His deposition was taken first. We all know that these doctors are taken in advance. They don't show up in the courtroom. But a couple of the other points about the objection. We cited the law in our brief. Ohio law is clear. A hearsay objection is not an objection that has to be raised in a deposition. The same could be said with respect to the leading questions. We didn't really get to that, but I did object to the leading questions. And when I did, Mr. Patzfall's response was, I'm allowed to ask leading questions because he's an expert. Now, we all know that's not true, but so I did object. The objection had no effect on Mr. Patzfall's questioning. He went on to ask over 70 leading questions, including many that assumed incorrect facts, that Dr. Bogdanov did not tell Dr. Egabegi about him taking tramadol on their first visit, when the visit note clearly states that his medications he's currently taking include tramadol. He said that he asked a very leading question of Dr. Wonder, isn't it true that Mr. Bogdanov had complained about low back pain in the past? And Dr. Wonder says yes. Well, that wasn't true, and he did later correct it, but the damage is done because of the nature of the question.
Well, but is the damage done? Because it seems to me that if he asked a leading question that's premised on a false assumption, you should be able to bring that up in either cross-examination or other evidence and be able to show, like, look, this guy's a liar, he's a quack, whatever, and that would thereby be very damaging to their credibility.
I did bring that up. I did bring that up, and Dr. Wonder recanted some of it, and it was brought up in trial. The jury was showed the evidence that these items had been, that, for example.
But I guess my point is, I'm seeing how that leading question hurts you if you were thereby able to damage his credibility by showing that he was relying on a false assumption.
It requires the jury to understand the nuance, because it's that's why leading questions aren't allowed. Because Mr. Patzfall should not be able to get up there and feed facts, false or true, to a witness, especially a witness, as Judge Guckenberger said, is a professional witness. That he said, I know Dr. Wonder, all he does is testify in these cases. And that's true. Dr. Wonder doesn't need Mr. Patzfall to lead him around by the nose for an 80-page deposition. But he did it, he did that anyway over multiple objections. And it's cumulative. These things happen over and over and over and over. And, with isn't it true, Dr. Wonder, that everyone in the legal community thinks you're the best doctor in the city, or whatever as he said, that's not appropriate. We all know that's not appropriate. It's not admissible, not only because it's leading, but because it's improper character evidence. It wasn't fair to the client. These things never should have happened. Everyone knows they shouldn't have happened, yet they did.
And you're at your time, Mr. Butler.
Thank you.
Thank you all for your arguments this morning. We appreciate your time. The case will be submitted and we'll get out of